All right, trial attorneys, we're back. A lot of times we talk about overarching sort of national issues, but we want to talk a little bit about a local issue that has come up because it brings up a very relevant, important point here in Chicagoland area. Ricky, you want to talk about a young lady who recently was accused. I don't even say accused; it's alleged. She's still cloaked with the presumption of innocence, but she's accused of participating in a carjacking that ended up murdering an Uber driver. The Uber driver ended up being murdered during the carjacking. Now, that in itself is a horrible allegation, of course. But what I wanted to really talk about it was, it brings up the issue of the Pretrial Fairness Act. And Ricky, with the Pretrial Fairness Act, what's the difference between, in Illinois now, what's the difference between, detention and how we used to have it before?
Well, back in the day, it wasn't that long ago, judges could set bond or no bond based upon the accuser's background or the seriousness or the nature of the offense. He or she could either say no bond or this is $1 million bond.
Right.
But what happened, there were cases, even when I was a prosecutor, I had guys who couldn't even post $100.
Yeah.
And couldn't get, literally. I wanted to give them this $100.
Right.
They literally could not post that bond.
Right.
So to try to correct that, they eliminate the bond requirement.
Right.
So now they have what these we call these pretrial detention hearings.
Right.
And before it was whether the person was a flight risk and all that type of stuff, but that's changed now. And what I found now is that the opposite has occurred.
Right.
More people are in custody. It didn't work.
Right.
And then if a judge, they had one judge, it was a domestic case. They released the person, and then I think later on he went out and maybe murdered a girl, and everybody was up in an uproar. They basically kicked him out of domestics and put him somewhere else, which I think is unfair.
Right.
Because you can only make the decision of what the information you have in front of you.
That's correct.
A person could have it being there for suspended license and go out and murder somebody.
Right.
But so I think what happens is it has an effect where, when in doubt, just detain them. That way I don't have to worry about the backlash, which really defeats the purpose of the pretrial detention.
Right. And I'm bringing up this particular case that happened over the weekend, I believe, where Uber Eats driver was delivering a meal. Allegedly three assailants came, attempted to, or took his car. And in the process of that, he was either hit by the car and left for dead.
Yeah, I think he ran back in. I'm like, was the car running? Never leave your car running. Don't put your keys. That's a side note. But I think he came back and tried to prevent them from driving off, and then she drove off, and the car ran him over, killing him.
Yeah. And that's a horrible act in itself. But I bring up the discussion about the Pretrial Fairness Act because this young lady that they have in custody for this crime has 8 prior felony convictions, yet she was on electronic monitoring for a present allegation when she committed this crime. So what does that mean, Ricky? She's on electronic monitoring?
Well, basically it's called house arrest. That means you are required to stay in your home. They put a ankle bracelet where they can monitor you to see where you are. They can track your movements. If you're supposed to stay in the house, if you leave, then you violated the conditions of your pretrial detention.
Right.
And now, they give you certain days, usually 2 days, where you can do certain things like grocery shop or whatever, wash your clothes, that type of thing. So that means, it appears to me, that means she left her house. Either she had the bracelet on her or she cut it off.
Right.
Either way, if they cut it off, they should have been going look for this young lady.
Right.
They should have been looking for her.
Yeah.
So clearly, I will say clearly, it appears that she, being under house arrest was meaningless to her.
Right. I mean, it was a big change. I remember when Pretrial Fairness Act came into play, because just like many other states, there's always been bond here in Illinois. You know, the whole time we've been practicing, you would get accused of a crime, you go to court, and it was arbitrary. Judge would just arbitrarily think of a number. You know, you got to pay $1,000. You got to pay $500. Now, I use the word arbitrary because there was no set amount that had to be set for any particular crime. But a judge is supposed to use their experience and their expertise and their knowledge, and supposed to use that to gauge a correct number. But like you said, there were people who, you know, couldn't pay the $100, and they were in custody for taking, you know, a Kit Kat or something.
Exactly.
They were
Retail theft, yeah.
sitting in jail. But so the answer, some people thought, was, you know what, let's go away from having people pay money, and let's go to this detention sort of protocol here. It's similar how they do it in federal court, similar how they've been doing it in juvenile court for a long time in Illinois. But that was a new system. But what they didn't do when this pretrial detention system was a pretrial fairness, or what it's called in Illinois, what they didn't do, it didn't seem like they really talked to any attorneys who were in court. I didn't. Did you get a invitation to go talk to Illinois legislator about?
I'm not even on that Christmas mailing list.
Yeah, I know. So they didn't talk to the people who were actually in court about if this would work or not.
Exactly.
Because what we're seeing practically, like you said, is that it's not working the way I think people thought it was going to work.
Exactly.
There are more people clients, especially of mine, who were in custody, who before in the past, they would have been able, if their family come up with some money, they wouldn't be able to get out and fight the case, on bond.
I just, as a note, remember, during the COVID, the population of jail dropped because they were releasing people.
Right.
Now they just filled it back up with this pretrial. It's filled right back up.
Yeah, yeah. And so the odd thing about the Pretrial Fairness Act is that there are certain crimes that are detainable just off the bat.
Like murder,
yeah,
sexual assault.
Right. But the thing about it is, people, even before when there was bond, if you were accused of something that's serious, you probably weren't getting out anyway.
Yeah.
Because the bond would be set so high, unless you happen to be independently wealthy, which wasn't too often, you were going to be in anyway.
You're going to be in anyway.
So it in my opinion, didn't really make much of a difference. And actually, it's keeping people in custody more.
Yeah.
But with this case,
just say we're doing something.
Yeah. With this case, she has the 8 prior convictions, but she's out. So it could have been a lot of reasons why she was put on electronic monitoring with the new Pretrial Fairness Act.
Well, one thing they did when I looked at it, they never said the disposition. You could be charged with aggravated battery, and it was dismissed or was found not guilty. They didn't say what was the disposition. Another thing that I always argue at these pretrial is they never talk about the presumption of innocence.
No.
Is that gone? He's presumed innocent, right?
Well, that's what we say and what we think. But we know the reality of these things and criminal law is that you are guilty to proven innocent.
Yeah.
Everybody, when you walk into that courtroom, everybody except for your defense attorney and your mama think you did it.
Well, that's when we do jury trials. We tell them, the state has a burden of proof of proving you guilty beyond a reasonable doubt. But we tell them our job is to go in there and prove you innocent.
Yes.
We're being proactive.
Yes.
We're not going to sit back. We're going to be proactive.
Mm-hmm.
And I think that's pretty sad that that's lost in all the.
It is sad, and that's why more often than not, I think pretrial fairness, it doesn't work, because one of the prongs is, or one of the parts of that a judge has to look at is this person a danger to society, or a danger to a person, a particular person,
like in a domestic case, if there's a boyfriend, he harms his girlfriend, or a guy who has a gun on him, but he didn't have a FOIA card. He's not a danger.
No.
If he's working and he was too lazy to put the gun in the trunk, is he a danger to? No, he's not.
Right. But many times prosecutors, they just argue blindly. I would say, in my opinion, many times they just argue that someone, because they're accused of a crime, that they're a danger to society. It's counterintuitive, don't you think?
Yeah. And I hear it's almost like fill in the blank. I think they have the form and they just fill in the name.
Right.
It could be a retail theft or murder, but it's the same argument.
Right.
And when they argue, well, if he's on, I had several actually, well, if he's on house arrest, he can go out and commit another crime. Of course, that's true.
Right.
That could happen.
Right.
But you're defeating the purpose of what the act is for.
Right.
If that's the case, then why do we have the act?
Right.
If your argument is everyone that's on house arrest is going to commit a crime, that could happen.
Yeah. Well, the act itself, the Pretrial Fairness Act itself, says that everyone is presumed to be out. That's what the act starts with. Every person that comes in here is presumed not to be in custody. And then the prosecutors have to overcome that presumption. Yeah, they have to show, we have to overcome that. But that part is more often than not is just glazed over. Yeah. Judges glaze over. Judges, Chicago is a huge city. It's a lot of people. It's always something happening. But judges, it can be someone, it may consider a tough job, but that's the job he signed up for. And he's supposed to be able to make those tough decisions. If
you can't do it, why are you there?
Mm-hmm.
Why you taking the check?
Right. You got to make those decisions. So,
and take the heat that goes along with your decision.
Right. So
own it. That's all I am. If I make a decision, I'm owning it.
Mm-hmm. So why is it that this young lady who has this criminal history, she's out, but somebody who perhaps their first arrest, they may be in custody. These two things aren't exactly equal in the way it works. So you think the old system or the new system is better?
I think the old system.
Why you say that?
I think the new system, they're more lean to detaining him.
Yes.
They play it safe.
Mm-hmm.
When in doubt, detain him.
Mm-hmm.
I had a juvenile. He got supervision as a juvenile on a gun.
Mm-hmm.
And while on supervision as an adult, he picked up another gun case.
Well, and supervision meaning that it was a misdemeanor, and supervision means it's not even a conviction. So that's the lowest punishment basically you can get.
And the police pulled him over. He was cooperative. Hey, I smell marijuana.
Yeah.
That type of thing. Didn't find a gun.
Mm-hmm.
His family's there. He's working. I mean, he never admitted the gun was his. Well, I mean, that's they find a gun. It's the car's registered to him.
Mm-hmm.
But is he a threat?
No.
Yeah. His family's there. He was working, graduated. I know the knee-jerk reaction, but that's 400 million guns in this country. Everybody got a pistol.
Yeah, sure. I know.
I mean, is it shocking that you could stop every fifth person on the Dan Rand Expressway? Somebody got a gun.
Yep. Mm-hmm. Exactly.
So I thought in that situation, house arrest, I think would have been no.
Yeah, I had a client who he hadn't gotten in trouble for his prior criminal history. Was over 20 years old, and he was working, had a family, actually worked in the community as well, and a vehicle he was in was illegally searched, and a gun was found in it. He was charged, and he was held in. He wasn't released. The judge decided he was a danger, even though everything happened his past was so long ago. That case ended up getting thrown out, one emotion and whatever. But and I even argued that during the pre-trial, this car was searched illegally. Judge like, well, and then a person still detained.
Technically.
Yeah. So with the old system, that person at least would have probably got a bond. Exactly. He had a lot of family there, and they could have probably come up between 20 adults. You can come up with $1,000, whatever.
People post their houses.
Mm-hmm. And
it's collateral.
At least he wouldn't have had to sit in custody. And he was fortunate that his job, they kept it open for him. But what if he lost his job because you had to spend a weekend in jail or whatever?
People lose their job with a pending misdemeanor. If they look and you got a pending case, you got to go.
Mm-hmm. Mm-hmm. So, it's just a prime example of the disparities of what can happen. Yeah, I think maybe people they had good intentions because they were thinking that person you were talking about with that $100. But the way you fix that is train the judges better.
Yeah.
If a guy is there and he stole a pack of gum, give him an I-bond. An I-bond just means you sign a piece of paper and you can walk out.
It is what it is.
Don't give him the $100. Oh,
I had a guy before the Pretrial Detention Safety Act. He had a bad background, but he was charged with stealing 3 packages of toothpaste. And this is a little bit different. And they was like, well, it's a misdemeanor. I'm gonna give him 64 days in jail.
what?
I said, for toothpaste, dude?
Right.
Really? See, that's what I'm saying. It's that mentality. It is what it is. You don't get that. Even though he had a bad background, it's $8 worth of stuff.
Yeah.
So I think it's that mentality of when in doubt, lock them up.
Yeah, and we've seen that from our working over the years, mass incarceration, it just doesn't work in that regard. Just putting everybody in jail.
How many times you ever heard a prosecutor say, back in the old bond days, oh, no objections to I-bond.
Right.
They're going to object just for the sake to object.
Right. It's just kind of like a knee-jerk reaction. That's just what they have to do.
Yeah.
But
for the record, object.
Yeah, it doesn't make any sense.
Yes.
But this, and I'm saying all to say this incident that happened over the weekend of what this young lady is accused of, now I think even more people are going to be held in custody now.
Well, just kind of based upon some of the information, if she was on house arrest and she's out committing other crimes, there's a justification. I could see a legitimate argument to detain this woman. But like you said, now, I think a lot of judges are shell-shocked.
Yeah.
They fear if they release this person that the heat's going to come on them. How many people, just like these order protections, how many people actually go out and murder a woman after they are accused of slapping her? Not to justify that.
Right, sure.
I don't like men who put their hands on women anyway, but that rarely happens. But when it happens, it's oh, you let him out on the bond? Oh, you let him out on EM? But he has no background.
Right. As long as you...
It rarely happens. It's always that one case that supersedes the thousands of other cases where it doesn't lead to someone being killed.
Yeah, as long as you can justify your decision. Even when I had great supervisors when I was a prosecutor, and they always said, well, do what you think is best. And as long as you can justify what your decision was, then that's fine. But if you, even as a judge, if someone asks you, why did you do that? If you go, then that's bad. But if you can say, no, I thought about this, I thought about that, and I came to this decision, then okay. I'm fine with that.
But then they go out and commit a murder, then they act like they don't know you.
Right.
What?
That's ridiculous.
Exactly. What were you thinking?
I don't told you.
You told me what? What are you talking about?
Who are you? Yeah, but it's a struggle, and it's a part of the job though. Judges.
Well, I think what happens, and I'm just talking about personal experience with the state's attorney's office. Like when I first started, you had 3 state's attorney room. In the room, you were allowed to make that decision on the spot.
Right.
We went to college, we went to law school, whatever, and you're in that courtroom, you're reading it. Now it's a little more different now. I think, and correct me if I'm wrong, but now you got to go through the first chair. You got to go, you got to go through, wing supervisor. Yeah. While we're in the room, we're in the trenches. Do you make mistakes? Oh, everybody makes mistakes.
Sure.
But you make that judgment based upon your experience, and you I was on what's called felony review. I interviewed the witnesses. A witness, I just didn't believe him.
Right. Yeah.
But we decided to go charge the complaining witness. But I'm there talking to her. Right. But, I'll not charge him anyway. Okay. Why am I out there?
Yeah, it belies.
So you had more discretion when you were in the courtroom as a state's attorney in the trenches, actively involved in a case, I think, than they do now.
Yeah, and that's where the biases and discrepancies in the law lie, in that it comes down to human decision making.
Exactly.
You know, someone says the law says this, but a judge can just, I'm not doing that. Or the law says this, prosecutor can say, I'm not doing that. And the ways you try to work around that, but those are the biases that you have to deal with on a daily basis. And that's why the law, you can get two cases, the accused are both exactly the same, the cases are exactly the same, and get two completely different results.
Exactly.
Depending on where you're at, what judge, who the prosecutor, completely different results. And that just has to do with, human beings.
Yeah.
Maybe we'll be replaced by AI. You just go to court and, you talk to the screen and it tells you.
I don't know why people are so excited about AI. I'm like, a lot of y'all gonna be losing your jobs.
Yeah, I mean, people. I don't know. It's new technology, man. I don't know.
I know, but still, I mean, we're gonna have robot lawyers. You and I'll be out there,
Mm-hmm. Well, I guess I got to go back to, I don't know. I can always
Chippendale days.
Yeah. I got to get back. I got to get back in the gym. See what I can do. But if it happens, it happens. But I don't think it'll ever happen with practice of law, because it's just
no. A lot of judges were upset that lawyers are using AI for their citing their cases, and then they got it wrong. And the judges have gone off on even held some attorneys in contempt. I think it promotes laziness to me.
Yeah.
But I just got rid of my VCR and solar calculator. So
okay, well,
kicking the screen,
right.
So I'm beyond AI now on this.
Well, the fact of the matter is, we're talking about here the Pretrial Fairness Act isn't necessarily fair. I don't think it's working the way the legislator thought it would. But I guess good for trying something new. You try something. Sometimes
and then if it doesn't work, maybe you need it. I think they react. Like you said, it's a good point. I didn't really think about it. Talk to the people who represent them.
Mm-hmm.
Get their opinion.
Yeah. No one ever wants to talk to us defense attorneys. No one likes us, man.
I know.
No one, everybody.
Remember before when they allowed the public defenders to get access to the clerk's computer?
Yeah.
They didn't give us access.
We had to reach out and scream, and we want access too. Wait a second, we're attorneys. We want to know what's going on. But and nobody
thought about us.
No, nobody thinks about us, man. It's kind of sad.
But I think they need to maybe every so often the judges need, and maybe the legislators, along with defense attorneys and prosecutors, every now and then do a review of it.
Yeah.
Every 2 years, sit down and see what amendments, not just the politicians, because the politicians are not in the courtroom.
No.
All they hear is, oh, he went out and killed someone, or he went out and that's all they hear.
Right.
But they don't know about the actual human aspect of it, the technical aspect of it,
right,
the actual aspect of it. And people sit down and talk about it and say, I think you need to do this.
Right. That would be the smart.
Because you could train a judge, but that doesn't necessarily mean he's going to do it. If he's already says, I don't want to risk getting no heat because of it, so I'm just going to detain him.
Mm-hmm.
So I think they should have a review every now and then and talk about it.
That would be good. You mean people actually review things, seeing if it's working, and then if it's not working, figure out something that would work?
Yeah.
Oh, wow. You want to be president?
I'll be president of the United States?
Yeah.
They'll be scared if they send me at the podium.
Oh, okay. All right.
A lot of people gonna get locked up. If I walk up and you don't want to be president.
Got it. Okay. So I mean, I just wanted to, get into something that had kind of local relevance here, in Chicago in Illinois, Pretrial Fairness Act. You know, it's something that's new, and it's really, I think a lot of people have misconceptions about it.
Can I ask you a question? So, which you think is better, the Cook County Sheriff running the electronic program, or the chief judge?
Oh, definitely the sheriff.
That makes sense.
Yeah, they have law enforcement capabilities. They're used to it. Because in Illinois, they switched recently. It was the jail they used to monitor electronic, and the Cook County Sheriff. But then it switched to a different administrative body has no law enforcement wing.
Just what you gonna go out there with the guys accused of attempted murder? Like, hey, you come here.
Yeah.
What you doing?
Maybe. Yeah. Ask him to write a essay about why he's violating his curfew. But yeah, the Cook County Sheriffs are definitely more equipped to handle that.
Do you think it would have had a different impact on this case with the Uber driver and the young lady running him over at the sheriff?
Maybe, because if she was on a curfew, someone might have noticed earlier that she wasn't back where she was supposed to be, and maybe they would have sent somebody out looking for her.
Yeah, normally if you they are alerted if you move away from where you're supposed to be, so automatically they start looking for her.
Yeah,
you know what I mean.
Mm-hmm.
So if you have someone an administrator at the chief judge, they have no. I assume they have no police powers.
Right.
They're not armed. What are they gonna do? They're gonna call 911?
Yeah, help me, please, help me. Somebody's getting away. Yeah. So these are things that, again, if you just talk to the people in a courtroom, you would probably get a completely different answer, and you could actually figure out what would work.
Because we talk to these guys, like, dude, you got to stay here. I was asleep. No, that doesn't work.
Right.
You know, when they came knocking, and when the sheriffs come knocking at your door, that doesn't work. You're gonna get locked up.
Yeah.
I had to go see my girlfriend. That's not gonna work. You know what I mean?
No.
So we know what's going on.
Mm-hmm. Mm-hmm.
We are talking to the people who are on house arrest. We know them. We talk to them.
Right.
We hear their excuses.
Yeah, and that's a lot of times that's what we're dealing with. But it's it's something that I think it can be resolved. It can be worked out. We just it's going to take some thought. People are always resistant to change, but
that's true.
Change is not bad. Change is not a bad thing.
Well, I think over time, just as being a man, if you don't change, you're not a man. You're supposed to change from a boy to a man. So, I mean, change isn't how to say change for the better.
Right.
So when you change, you're trying to improve things. That's where it should be.
Oh man, that's good right there. Change. Well, I guess I got some things to think about some changing. Maybe, I don't know.
Yeah, run for judge. I'm too old, man. I'm set in my ways.
That way. Never know. You never know. All right, so we're gonna end it there. It's a great discussion. Remember, we're back. I know we've been away for a while, but we'll be coming back more often. Subscribe, follow us, check it out. Okay. All right, thanks.